Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hey guys, what's up? You know, it is getting so hard to stay classy. It's getting so hard to stay classy. You know, I try so hard. I really try. But it is really becoming like I am on my last nerve today. And I don't want to bury the lead here for those of you who don't know, because they're going to spoil it. No, they're not going to spoil it. They're just, people are excited and they want to talk about it because they're very angry. They're outraged. They are angry. They are outraged. Judge Cannone has denied Mark Bederow's application to come into the Karen Reed team pro hoc vice. We're going to go over the decision. We're going to go over the papers that Yannetti filed this morning because she asked for some additional papers. And it was quickly denied. Then we've got a motion from Hank Brennan to correct the record. We've got a motion from Hank Brennan to extend his time to do some things and stuff. And I am waiting at the edge of my seat for the decision and order on the sanctions motion, which has been docketed but not yet scanned. So there's a lot to get to. Grab your popcorn, grab your drink, get a cocktail. I'll allow it. I don't care what time zone you're in. I will allow it. It's a lot. We're going to be here. We're going to talk about it together. Because I already know the decision on Bederow, I am now more interested to see the order on sanctions and the oral motion to prohibit extrajudicial statements of counsel, which was the gag order that Brennan didn't put in his papers, but argued on the record regardless, because pretty much he's allowed to do whatever the duck he wants. It doesn't really matter. It doesn't need to be in writing. Just get up. Just get up and say whatever you want. Do whatever you want. Earlier, when I was doing the stream on Brian Walsh, I saw that Peter Tragos went live to talk about the Bederow thing. And so I think some of you probably went over there to watch it. I didn't watch his stream because I like to give you my own reaction. Yes, and he did do, thank you, Maeve, he did a video, I think it was yesterday, on judicial bias. And listen, he tries to walk the line. He really does. He tries to be fair and he tries to see both sides of it. But in this case, he said yesterday in that video, he just can't. He just can't. He says this is like the most blatant judicial bias that he has ever seen. And for Peter Tragos to say that, that's a lot. That is a lot. What should we do first? Well, I guess we should do Bederow first, right? Except Maybe we want to do that last so we can go over the rules. I don't even know what to do first anymore. I really don't. Let me just, why can't I download this? Hello. Hello. Download blocked? Why? Why is it blocked? Unblock it. I've never had that blocked before on my computer. I don't know what just happened. I've always had cookies blocked and okay, whatever. It's going to be one of those days. It's already one of those days and it's Friday. It's supposed to be a good day. Friday's supposed to be a good day. But we're here. My wine bottles are even popping off, says Witch in the Wardrobe. My wine bottles are even popping off. Here we are here. We are in the Lion, the Witch, the Wardrobe, the Matrix, the Narnia, the Upside Down, Inside Out, hellhole. That is Norfolk County, Massachusetts. Many of you live there and you know, because unfortunately you have been dealing with this for decades. Decades. So what we're going to do, I guess, well, so while we wait for some people to go in here, because I think there's some other people live. So let's look at number 552, docket number 552, which is Hank Brennan's Commonwealth motion for extension of time to file, because he should get all the courtesies and the defense should get none. Here we go. Commonwealth's motion for extension of time to file motions in Lemonade related to the defense expert reciprocal discovery. Docket number 552. I don't have a stamped copy, but this was just filed earlier today because I think the first thing that we saw filed today was docket number 5. What's today? The 7th. So the first thing was 549. So this is 552. This is Hank Brennan's motion for extension of time to file motions in limine related to defense experts reciprocal discovery. Now comes the Commonwealth in the above captioned matter and respectfully moves this honorable court grant the Commonwealth an extension to file motions in limine related to expert witnesses. You remember that Hank Brennan already asked for an extension. They were supposed to be due today, but the judge said, okay, Mr. Brennan, I'll give you until Monday. And then Ms. Little was just kind of looking around and the judge was like, oh, Ms. Little, would you like until Monday too? And she was like, well, yes, I'd like to be granted the same courtesies that you're going to give the Commonwealth. And so both of their times to file motions in limine are extended until Monday. Today is Friday. So that makes Monday the 10th. But the 10th is not going to be good enough for Mr. Brennan. And here's why. He says the defense provided notice of 12 defense experts and partial expert disclosures on March 6, 2025. So that was yesterday. That was the day that their disclosures were due. The Commonwealth moves for an extension of time to permit the Commonwealth an adequate opportunity to review the defense experts' reports to prepare any appropriate motions in limine. The Commonwealth requests until March 14th to file motions in limine regarding the expert disclosures that the Commonwealth received on the 6th. So he wants until next Friday. They're supposed to be due Monday. He wants an extension until next Friday. I say, listen, they're paying you $250,000 to come in here as a hired gun because nobody in the office wants to touch this case. Maybe you get what you get and you don't get upset. Maybe some deadlines should apply to you. I don't know. Just a thought. Maybe you've got a huge office over there at the Norfolk County DA's office, and maybe, just maybe, since you have not been able to grant any courtesies to the defense, no courtesies should be granted to you. But that's just me. You know what the judge is going to say. Of course, Mr. Brennan, take whatever you need. Do whatever you need. Furthermore, the Commonwealth has not received further disclosures relative to the ARCA witnesses. Nor has the Commonwealth received reports or anything besides a CV for 2 noticed experts. For those witnesses, the Commonwealth reserves their right to file motions in limine at a time after the required disclosures have been provided. You know what he's like, Hank Brennan? He's like the tattletale that everyone hated in kindergarten. He's like the tattletale. He's like the one who would go run into the teacher to complain about everything. Because that's what he's doing here. The Commonwealth anticipates filing all other motions in limine on Monday, March 10th, 2025. So Judge XOXO, Hank Brennan, we'll file everything else by Monday, but they just, Your Honor, they just gave us 12 experts and partial disclosures, and they didn't give us everything that we need, and blah, 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 wham, 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 nanny, nanny, poo, poo. He's a weasel. He's a weasel. 12 experts. You know what? That makes me really happy. That makes me really happy. So we're going to find a little silver lining in this touch of gray right now. We're going to find some silver lining. And the silver lining is that apparently the defense has 12 defense experts that they turned over yesterday. I don't know who they are. But good. But good. Because the army is here. The big guns are coming. And who's afraid of little old me? Well, you should be. You should be. You should be. And you know what? I mean, in other breaking news, it is rumored that Harry Styles is going to be doing a residency at the Sphere, and I have some daughters that are really happy about it. And quite frankly, so am I. I'm happy about it too, and I will be there. I've seen Harry Styles before in concert, and let me tell you something. He's amazing. And so there's that. Okay, so that was dropping number 552 that we just looked at. And now we have 554. Oh, yes. Hank Brennan would like to correct the record. Again, I don't know why my browser is not allowing me to download things. This has never happened to me before. What the duck? Okay, it says they're allowed. I need a tech department. I need an entire tech department. Deep breaths. Okay, well, I'm not going to be able to download it, but hang on, because I think we need to go to 553 first anyway. So there's that. So there's that. And then we have. Where's the affidavit? I'm sorry. I was totally not organized for this because this is like a last minute thing that I just threw on the calendar when I was in the middle of doing Brian Walsh. But, you know, it's just talk amongst yourselves for a second. For the love of the traveling Mary. I don't know. Did Google update itself and now it's not allowing me? I don't use Safari. I hate Safari. Oh, and also I came across some proof that, well, here's the smoking gun. Perhaps Coleen Crawford and Fanning have been doctoring videos since at least 2015. I've got receipts on that. So hang tight because we'll do that afterwards. All right. Well, did somebody else send it to me? Here is the supplemental affidavit. We're going to go here because everybody's talking about it anyway. So let's do this first. Defendant's supplemental motion for admission pro hoc vice of Bederow. So this was filed this morning by David Yannetti because remember, the judge was not satisfied with Mr. Yannetti, his first application to have Bederow admitted pro hoc vice. She was not satisfied. And she said, well, you know, you're going to have to, you know, give me some more information. Remember what happened when you wanted to admit Mr. Alessi pro hoc vice, and I wasn't happy then. Like, what part of that didn't you understand? Because I'm still not happy. And now you're still going to have to, you know, supplement the record. So here's the supplement of the record. This was filed this morning at 8:50 something a.m. So when I did have this morning, I figured, let me wait until the end of the day and do everything that drops today. Yes, I agree. They're probably the next thing that's going to happen probably Wild Man's Mom is that they're going to shut off the cameras because Judge Cannone is saying to Judge Gull of Delphi, Indiana, hey, Gull, check this out. Hold my White Claw. I'm going in. I've got the documents. I have everything. I just couldn't exactly find it exactly right now. So thank you for that. No need to call arms. I've got my paralegal working on 555. It has not been scanned yet. As soon as it does, we're going to do it. Hold my White Claw. Yeah. Here you go. So here, this is the supplemental motion of admission pro hoc vice of Mark Bederow by David Yannetti that he filed this morning. David Yannetti of the Yannetti Criminal Defense Law Firm and a member in good standing of the Massachusetts Bar hereby moves to admit pro hoc vice Mark Bederow so that he may associate in as counsel of record for the defendant in the above captioned matter on the following grounds. I'm also going to say to you that I've never seen a pro hoc vice application denied, ever. I've been doing this for over 30 years in New York, and I've never seen it. But, there's a first time for everything. If there's going to be a first time, it might as well be in the Karen Reed case and in the courtroom of Justice Beverly Cannone. Number one, at this court's directive, this affirmation is intended to supplement my pending motion for admission pro hoc vice of Mark Bederow so that Mr. Bederow may represent Karen Reed at her upcoming trial before this court. I incorporate by reference all the contents of my previous affirmation in support of that motion. The source of the information contained herein, describing Mr. Bederow's qualifications and background, comes from my conversations with him and information he has provided to me. If the court requires any additional information not contained in this affirmation, Mr. Bederow is available to speak to the court ex parte, meaning without the other side involved, about any issues relevant to the motion. Mr. Bederow has been a member in good standing of the New York State Bar since 1999. He is also admitted to practice in the state of New Jersey, the Southern District of New York, and the Eastern District of New York. He has been presently admitted pro hoc vice in Massachusetts on 3 criminal matters, 2 of which are pending in the Norfolk Superior Court. The other matter is pending in the Dedham District Court. In 2009 and 10, Mr. Bederow was admitted pro hoc vice in the District of Connecticut in connection with a complex federal criminal matter. In more than 26 years of practice, Mr. Bederow has never been sanctioned or disciplined by any court in any jurisdiction in which he has been admitted to practice. Good cause exists to grant this motion because Mr. Bederow has specialized skill and knowledge in representing criminal defendants in matters of this nature. Since 1998, Mr. Bederow has been engaged in the practice of criminal law. From 1998 to 2004, he served as an assistant district attorney in the New York County, Manhattan District Attorney's Office, which is one of the largest and most prestigious prosecutor's offices in the United States. From 2004 to 2008, he practiced criminal law at a large national law firm. Since 2008, he has had his own criminal defense firm in Manhattan. During his career, Mr. Bederow has been involved in many complex homicide cases and other serious cases, including some with issues similar to those in Ms. Reed's case. Ms. Reed values Mr. Bederow's experience and legal skills and desires that he be allowed to represent her in this matter at trial in this matter. As the court is aware, Mr. Bederow presently represents Aidan Carney on 3 criminal cases in Massachusetts. One of those cases involves several witnesses who are scheduled to testify against Ms. Reed. Prior to the filing of the instant motion, Mr. Bederow conducted separate and extensive discussions with both Ms. Reed and Mr. Carney, and we have discussed that at length when people were asking, how can he come in if he represents him and to represent her? And I said, it could be a waivable conflict if he advises both of them of the potential conflicts and they both sign off and they both waive the conflict. So according to Mr. Yannetti, prior to the filing of this motion, Mr. Bederow conducted separate and extensive discussions with both Ms. Reed and Mr. Carney. He defined and explained actual and possible conflicts of interest and the concept of waivable conflicts. He explained to Ms. Reed and Mr. Carney the possible conflicts that could arise in his representation of both in separate matters that involve some of the same witnesses. He answered any questions either client asked. He reviewed rules 1.7 and 1.8 of the Massachusetts Rules of Professional Conduct with Ms. Reed and Mr. Carney, and then presented both with copies of those rules. Mr. Bederow instructed both clients to speak separately with their other existing counsel about these issues. Both clients discussed these issues with their own counsel outside Mr. Bederow's presence. He had a conversation with them. He gave them the disciplinary rules. He told them to speak to their own attorneys about it before making any decision. They both consulted with their own attorneys. And after both clients expressed an interest in his representation, after they consulted with their own counsel, Mr. Bederow prepared a detailed written explanation of possible conflicts of interest and what could happen in the event of an actual conflict of interest. If there's one thing that I know about Mark Bederow, and you know too from reading the Bederow letters, is that he dots his I's, he crosses his T's, his punctuation is impeccable, his grammar is fantastic, his vocabulary is delicious, and there ain't nobody who covers his ass like Mark Bederow. He doesn't come unless he has receipts. Both clients, with the advice of their own counsel, acknowledged that they understood these issues, confirmed that they wanted Mr. Bederow to represent them, and executed written waivers to any possible conflict of interest related to Mr. Bederow's representation of Ms. Reed and Mr. Carney. Both Mr. Bederow and I can unequivocally confirm that there is and never has been a joint defense privilege between Ms. Reed and Mr. Carney. Mr. Bederow has not shared any protected material provided to him as part of his representation of Mr. Carney with Ms. Reed, her counsel, or anyone else. Mr. Bederow has never engaged in any conduct during his representation of Mr. Carney, or anyone else for that matter, for the purpose of harassing or intimidating witnesses against Ms. Reed and or Mr. Carney. Mr. Bederow will not share any protected materials provided to him on Ms. Reed's case with Mr. Carney or vice versa. Mr. Bederow had no role in the preparation of a recent motion filed with this court, which led the Commonwealth to seek sanctions over an alleged violation of a protective order due to the inclusion of a text message sent by Michael Proctor. Mr. Bederow was not provided any protected material by Ms. Reed, her counsel, or anyone else in connection with this motion. Shortly after that motion was filed, Mr. Carney's attorneys filed a motion to dismiss the indictments against him. We watched that hearing. Was it only yesterday? That motion included references to some text messages and electronic communications that were subject to a protective order in that case. That publicly filed version of that motion, which is available for this court's review, includes redactions of any messages that are subject to the protective order in Mr. Carney's case. In one footnote, there is reference to a series of many inappropriate statements made by Michael Proctor, all of which were in the public record before Mr. Carney's motion was filed. Because remember, Brennan got up there and said, they've been sharing this protected information all along. Listen with the breaking news. Stop it. I have that order, and I am not going to allow it. I'm not going to allow it. I don't care if I treat you like a kindergarten class. Why is it that people can't just wait 5 seconds for me to finish what I'm already reading to go to the next thing? I don't know. But if you can't, then just go. Just go. So rude. I can't read fast enough. On February 18th, they did not object to Mr. Bederow's proactive admission or the defense before the country decided to motion and parties. So he didn't object, and so yeah, therefore, you should grant it. But anyway, hold on, because we have the sanctions motion decision, and before anybody else has to give you the breaking news, because I haven't even read it yet, so I don't even know what it says. Let's read it together. I just don't understand why. It's like the person who has to be the first person to tell everyone somebody died. You know what I mean? Like, that's like the vibe that I get. I don't know. I don't know. Maybe I shouldn't be doing this today. Maybe I should just not do this. I don't know. And this is like a weird copy. So how can I even pull this up? It's not a download. It's like I don't know what this is. Is this like thank you, Melinda, but is this like a screenshot? Hold on. Let's see if I can open it a different way. Because it's like too big. All right, hang on. Do you want to be me? Do you want to be doing this for hours and hours and hours a day, only to have people like break the news that everyone's waiting for before I have a chance to do it? It's just I don't understand people. I just don't. I can't chill. This freaking case bugs the bejesus out of me. I can't chill when a woman is facing 20 years in prison because of the goddamn bias of a judge in Norfolk County, Massachusetts. It's disgusting. It's absolutely disgusting. And if you don't see that and you don't understand why everyone's on edge, then I don't know what to tell you. I just don't. And I don't even know how to make this any smaller because it's like, whatever. And how many pages is this? Oh, wait, hold on. I can do it. Yay. But is that only one page? Melinda, did you only send me one page of it? What else? Yeah, I do. I need the dad. I need Jerry. I just need to walk away from this case is what I think I need to do because I don't know if I can do this anymore. I just don't. It's exhausting. Why is this not coming up on the screen? Why is it not? Hold on. See if I can get a cleaner copy. Because it's supposed to be like, it's a lot of pages, right? All right. Well, we'll start here and then we'll try and find page 2. This is the memorandum and decision. We're going to have to go back to the order on Mark Bederow because this is coming. Yeah, right. Can you imagine, Karen? I know. It's got everyone on edge. People are sick. People are physically ill over this case. And it's not even like our family. Like, we don't know. A lot of you don't even know these people. And you're like ready to, everyone's on blood pressure medication and getting physically ill about it. It's horrible. This is the memorandum of decision and order on Commonwealth's motion to impose sanctions pursuant to Massachusetts Criminal Rule 48, Criminal Rule of Procedure 48, an oral motion to prohibit prejudicial. This is the gag order motion decision. This is docket number 555, docket number 555. And I haven't read this. It's a cold read. So please don't even tell me what it's about because I don't know what it says. Please. Maybe I should just shut the chat off. Should I shut the chat off? Mods, would that be better? And then I could just sit here by myself and like record a video and then just put it out later. Like, I don't know. I don't know what the problem is. On June 9th, 2022, a Norfolk County grand jury indicted Karen Reed on charges of murder in the second-degree manslaughter while operating under the influence of alcohol and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th of 2022. Trial on the matter began in April 2024 and concluded on July 1st, 2024 with a mistrial. The matter is set for retrial on April 1st of 2025. Well, at least the judge knows when it's scheduled to start because in Brennan's papers yesterday, he said January 27th, 2025, which is in the past. There have been more than 500 filings in this case, many of which are subject to protective orders. The case has generated significant media attention locally and nationally, with the defendant and defense counsel participating in numerous interviews with media outlets. In addition, the court is aware that there was also a federal investigation into the investigation of O'Keefe's death. Okay, well, she's saying the investigation was into O'Keefe's death, not into the DA's office or the investigators. And I don't think that we even really know what it was about, but that's what she's saying. Recently, the Commonwealth represented in open court that the federal investigation has concluded without the issuance of any indictments. Well, they said that. The Commonwealth represented that. But as far as I know, the U.S. Attorney's Office has not confirmed that, because I haven't seen it from the horse's mouth. So we don't really know. But she's going to take Hank Brennan's word for it, because we know how he has been so married to the facts when he gets up and speaks in her court. He's never misrepresented anything. He's always telling the truth, right? Before the court are two motions: the Commonwealth's motion to impose sanctions pursuant to Massachusetts Criminal Rule 48, and an oral motion made by the Commonwealth to the court on March 4th, 2025, renewing its prior written motion seeking to prohibit extrajudicial statements of counsel that would have a substantial likelihood of materially prejudicing these criminal. I don't know if I got all these pages, so hang on. You got to hold on while I find page 2, because first of all, that's not true, because Hank Brennan did not say that he was renewing the motion for a gag order. Hank Brennan just got up and started, and he probably doesn't even know that there was an order for a gag order. He probably doesn't even know that. But, he just said that up, and she's just going to, take him at his word. Now we're going to flip over to this. We're going to have to try and do the best we can with the copy that we have. And I do appreciate it, Melinda, so much. But this is like all we have right now. Hold on. Okay, that would have a substantial likelihood of materially prejudicing these criminal proceedings. For the reasons that follow, the court will deny. Come on. Come on. Just go smaller. Why can't you just go smaller, please? I'm really not in the mood for this today. For the reasons that follow, the court will deny the Commonwealth's motion for sanctions. Oh, well, that's nice. Under Massachusetts Rule 48, and allow the Commonwealth's motion for an order limiting extrajudicial statements of counsel. Well, okay, no sanctions, but gag order. Okay. But remember, the gag order does not apply to us. It does not apply to Karen. It only applies to the defense counsel. All right, wait. Ooh, wait, maybe that'll work. No. See if we can make it smaller. Can we? Oh, this works. Okay, here we go. No? No. I swear all the gods are against me today, all of them. Maybe that'll work. Discussion. No, because when I try and scroll, it's just gonna. Okay. Can you read that? No, it's a little small. No, there was no previous gag order. They asked for a gag order, and then it was denied. And then that's when Michael Marcy went on and did his hostage statement. Discussion. I feel like we're in 1980 with AOL dial-up internet, and it's just, it is what it is. Discussion. Commonwealth's motion to impose sanctions pursuant to Rule 48. Pursuant to Massachusetts Rule of Criminal Procedure 48, a willful violation by counsel of the provisions of the Rules of Criminal Procedure or of an order issued pursuant to these rules shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition of costs or a fine. The purpose of Rule 48 is to allow judges to regulate the conduct of attorneys who practice in the courts of the Commonwealth and to discipline those whose actions fall short of accepted standards. And if you're getting nauseous, I really am sorry about that, but I really can't do about it. Nor can I do anything about anyone's misophonia when I swallow into the mic. So I'll try not to do that today. The purpose of Rule 48 is to allow judges to regulate the conduct of attorneys who practice in the courts of the Commonwealth and to discipline those whose actions fall short of accepted standards. See Reporter's Notes to Massachusetts Criminal Procedure 48. In addition to the sanctions of citations for contempt and the imposition of costs or a fine, the rule contemplates referral to the Board of Bar Overseers where appropriate. Okay, so in New York, we call it the Grievance Committee. And I guess that it is called in Massachusetts the Board of Bar Overseers, and that is the body that governs attorneys and grievances against attorneys and ethical complaints against attorneys. Hold, please. Thank you. Calypson's Vixen for saving the day. I appreciate you so much. Okay. All right, we're going to get it right. This is live television. I mean, what do you expect? It's live. It's live. It's not Memorex. It's 100% live. It's 100% fallible. And it is such a fun thing to do, this live streaming, especially when you can't control your emotions like me. But if you know me, I mean, have you met me? I mean, you've met me, right? Like, you've met me before, haven't you? So you shouldn't be surprised. Calypson's Vixen. Woo woo. Oh. All right. Let's get the red pen out. The Commonwealth's motion for sanctions is in response to the defendant's motion to reconsider reciprocal discovery order, wherein defense counsel quoted information subject to protective orders issued by this court on November 13th, 2024 and January 31st, 2025. Attorney Yannetti has acknowledged that this motion, which was not protected from public view, should not have included protected information. He did get up in open court and say that. It was my fault. My fault. I'm sorry. He fell on the sword. However, he represents that the inclusion of protected information was a mistake and not a willful act. As a sanction for this conduct, the Commonwealth requests that this court issue an order that the defense file all motions under seal and impounded until such time that both the Commonwealth and the court can ensure that the filings comply with all previous orders set by this court. The sanction sought by the Commonwealth is not appropriate under Rule 48. Praise be all the gods. Rule 48 allows for the imposition of punitive sanctions on individual attorneys who intentionally violate the rules of criminal procedure or the court's orders. See Rule 48. Sanctions that may be imposed include a citation for contempt, or the imposition of costs, or a fine, or referral of the matter to the Bar of Board Overseers. I will just tell you, that's a place you don't want to be. You do not want to be in front of the Board of Bar Overseers or the New York State Grievance Committee. Citing Commonwealth v. Frith, which says Rule 48 permits punitive monetary sanctions on counsel. Although procedural remedies such as the initial impoundment of documents sought here are available under other rules of the court, defense counsel has assured the court that it will take more care in the future with protected information in court filings. The court, therefore, declines to impose any sanction under Rule 48 at this time. Well, I mean, that's shocking. However, subsequent and/or repeated violations of court orders may well be considered either willful or conduct or careless indifference that warrant sanctions by the court as permitted by the rules. And look, they're not going to do it again. The issue was that they put a text message in there from Proctor or a screenshot of a text message that said a text message from Proctor to Lally that said, I didn't watch that a-hole's closing, referring to Alan Jackson, because, we're also worried about the verdict or something like that. Commonwealth said that was under a protective order. You should spank them. And also, I think he said that he referred to the juvenile witnesses, but I think it was mostly about that text message, right? Point 2, and this is the judge's order on the sanctions motion if you're just joining. Commonwealth's motion to prohibit extrajudicial statements of counsel. Few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors and an outcome affected by extrajudicial statements that would violate that fundamental right. Thus, restraints on extrajudicial statements by counsel may be warranted in a particular case to protect the integrity and fairness of the judicial system. However, the regulation of attorney's speech is limited. It applies only to speech that is substantially likely to have a materially prejudicial effect. Consistent with these principles, a court may issue a gag order which restrains the speech of participants in the proceeding if the order is justified by a compelling state interest to protect against a serious threat of harm and is no greater than is necessary to protect the compelling interest. Such an order must be supported by detailed findings of fact that A, identify a compelling interest that the restraint will serve, and B, demonstrate that no reasonable, less restrictive alternative to the order is available. The Commonwealth seeks a gag order to prevent defense counsel from making extrajudicial statements, which is a fancy way of saying out-of-court statements, in violation of the Massachusetts Rules of Professional Conduct 3.6a, and from revealing protected information to the public through the media. In June 2023, the Commonwealth filed a similar motion to prohibit prejudicial extrajudicial statements of counsel in compliance with Massachusetts Rule of Professional Conduct 3.6a. The court denied that motion, concluding that no trial date had been set and that this minimized the likelihood that extrajudicial statements would materially prejudice the proceedings. In so ruling, however, the court emphasized that all counsel are bound to comply with the standards for attorneys with respect to extrajudicial statements, see SJC Rule 307 and the Massachusetts Rules of Professional Conduct 3.6. The court also made clear that neither party should interpret this decision as precluding a future court order limiting counsel's statements. At the March 4th, 2025 hearing on the Commonwealth's motion for sanctions under Massachusetts Rule 48, the Commonwealth reasserted its request for a so-called gag order, arguing that defense counsel have violated the Rule of Professional Conduct 3.6 by making extrajudicial statements that counsel reasonably should know will have a substantial likelihood of materially prejudicing the proceeding in this matter and have put protected information into the public domain. In support of its oral motion, the Commonwealth asserted that the defense lawyers have a history of making extrajudicial statements that may prejudice the proceedings. It also submitted audio clips from an interview conducted by Boston Magazine reporter Gretchen Voss of the defendant and attorney Alan Jackson at the Omni Seaport Hotel on July 13th of 2023. Footnote 1 says, although this interview was conducted on July 13th of 2023, the Commonwealth only recently obtained the audio and shared it with the court. And cited to a recent interview aired on February 17th, 2025, that the defendant and attorney Jackson gave to Fox 25 News. Footnote 2, which says, at the hearing on the motion, Prosecutor Brennan also stated that attorney Yannetti appeared on Court TV falsely representing the subject of the federal investigation. In fact, Court TV played a clip of statements attorney Yannetti made on a Zoom hearing in court. We knew that. Thus, contrary to the Commonwealth's representation, the statements were not extrajudicial and thus are not considered for this motion. Well, isn't that nice? Based on these interviews and defense counsel's consistent publicly reported interactions with reporters and bloggers throughout the first trial, I think that's a diss to Aidan Carney. Just guessing. But I don't know that Alan Jackson or David Yannetti has ever spoken to Aidan Carney and that he's ever reported that, ever. The court agrees with the Commonwealth that an order limiting extrajudicial statements of counsel is both appropriate and necessary to ensure a fair and impartial trial, and finds that no reasonable, less restrictive alternative to the order is available. Well, that's what you call a gag order, folks. Gag order means the attorneys are not allowed to speak to the press. And neither is Hank Brennan. Outside of the courtroom. No courthouse steps. No interviews on your way outside of the courthouse. No interviews on Fox 25 or Boston 10 or Ted Daniel or anybody. It doesn't gag Karen Reed, mind you, but it gags her attorneys. During the Voss interview, the defendant, with Attorney Jackson seated at her side, told the reporter about witness testimony from the defendant's sealed grand jury proceedings. Specifically, while discussing Voss's recent visit to the Waterfall Bar and Grill, the defendant stated that the bartender who works there had testified before the grand jury. After further conversation, the defendant then told Voss the substance of the witness's testimony before the grand jury. The requirement that grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth in order to protect the process from extraneous influences, protect individuals from notoriety and disgrace, protect witnesses from intimidation and subordination or subornation, and encourage the free and full disclosure of information concerning commission of a crime. Did Gretchen Voss publish any of that in her article? Does anybody know? I'll have to go back and look later. Citing WBZ TV versus the district attorney for Suffolk District, and that's a 1990 case. No, she did not. People are saying she didn't publish that. So she didn't publish it. And now the judge has published it. And this is coming from Gretchen Voss's redacted portions of her interview. She redacted these portions, remember, on the tapes that she turned over. And then the court said you have to give them the unredacted version of those audio tapes, but you don't have to give them your notes because you're afraid for your life and no one will ever speak to you as a reporter again, because there is no such thing as off the record in Massachusetts, because journalists are not protected with any sort of journalistic shield or privilege as they are in most other states, which is just one of the other reasons that this case is so insane to many practicing attorneys such as myself and others. And maybe the reason why Karen Reed's team needs to go outside of Massachusetts to find other attorneys that are willing to expose the corruption. Because if you got to practice in Massachusetts, you might not want to be doing that, right? Not a lot of Massachusetts attorneys talking to the press on this. The ones that are in Massachusetts are the ones who are talking about how Karen Reed is guilty, hang her in town square, like Krowski, Wendy Murphy. I mean, name a Massachusetts attorney. Maybe Andrew Myers is saying that it's unfair. I think he's in Massachusetts. See also Rule 5D of the Massachusetts Rules of Criminal Procedure, which ensures the secrecy of the proceedings and governs disclosures. It specifically prohibits anyone other than a person performing an official function in relation to the grand jury from disclosing matters occurring before the grand jury, except in the performance of his or her official duties, or when specifically directed to do so by the court. Massachusetts Rule of Criminal Procedure 5D. Although Attorney Jackson did not himself disclose information about the grand jury proceedings to the reporter, he had two opportunities to intervene to prevent his client from disclosing such information. Instead, he sat idly by. Oh, there's a dig. Let's get the shovel emoji out, my friends, members. We have a shovel emoji for that. While his client disclosed to a reporter the testimony given in grand jury proceedings. Additionally, during the interviews with both Voss and Fox 25 News, Attorney Jackson disparaged witnesses in this matter. In the Voss interview, he specifically referred to two witnesses as, well, I should say as liars, but it says in the Voss interview, he specifically referred to two witnesses liars. Statements commenting on the character, credibility, or reputation of a witness are more likely than not to have a material prejudicial effect on the proceeding. Rule 3.6, comment 5, footnote 3, which says, this court also notes that Attorney Jackson had a conversation with Voss at Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery, but not yet made public. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery and told her that she could not publicly disseminate the information until it was put in a court motion. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing so that the reporter could put it in her article before publication. In the subsequent Fox 25 interview, Attorney Jackson claimed that, one, although individuals involved in the case know what really happened, they are not talking. And two, witnesses in the Albert home the night of January 28th, 2022, had obtained lawyers for self-preservation, which implies that they are not being truthful in their statements to law enforcement about what occurred. In the decision on the Commonwealth's first motion to prohibit extrajudicial statements, the court stated that defense counsel's statements to the media had at times arguably crossed the line of permissibility under Rule 3.6, but concluded that the risk of prejudice was minimized by the fact that no trial date had been set. With trial now imminent, and with the above-mentioned examples of improper statements made directly or indirectly by defense counsel, the court is no longer satisfied that the less restrictive alternative to the order previously given, the reminder to counsel that they are bound by the ethical and procedural rules, is sufficient to ensure a fair trial in this matter. The court finds that there is a substantial likelihood that continued comments about witnesses and evidence in this case by counsel in the future might well taint the jury pool. Therefore, an order restricting such statements is now both appropriate and necessary. Order. For the foregoing reasons, the Commonwealth's motion to impose sanctions pursuant to Massachusetts Rule of Criminal Procedure 48 is denied. The Commonwealth's motion to prohibit extrajudicial statements of counsel is allowed. It is further ordered that, can you hear my eyes rolling from Florida? Well done. It is hereby ordered that, one, none of the lawyers appearing in this case shall release or authorize the release of information about this proceeding that a reasonable person would expect to be disseminated by any means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing potential trial jurors or witnesses in this case. None of the lawyers. None of the lawyers appearing in this case, this is point 2, none of the lawyers appearing in this case shall release or authorize the release of information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Number 3, none of the lawyers appearing in this case shall release or authorize the release of protected information in this case, including information subject to a protective order or information protected under the rules of criminal procedure. Number 4, lawyers appearing in this case shall remain subject to all of the relevant provisions of the Massachusetts Rules of Professional Conduct, including Rules 3.6 and 8.4. XOXO, Beverly Cannone, March 7th, 2025. So the long and short of it is, no monetary sanctions, no referral to the Board of Bar Overseers, but the lawyers are gagged until this trial is over. Now, I want to point out to you, that does not mean that she's not going to throw Alan Jackson off the case, because that was not what this sanctions motion was about. That was during the ARCA motion that all of that stuff came up. See what I'm saying? That was during the ARCA motion. And that is when the judge had extreme concerns, grave concerns. And she went and took a half an hour timeout and then came back with her grave concerns, gave them a week to come back and talk about it. And that's the motion to exclude ARCA. That's not the sanctions motion. They are two different motions. And so we await further advice on that. Let me just check the docket and see if that came up. The lawyers are gagged. But no sanctions is good. But again, that was a motion that he made orally. It was not in writing, and it was not a renewal of the gag order motion, because I don't think he even knew. I really don't think he knew that there was a gag order motion prior in this case. Do you? Because that was made all the way back in like August of 2023, yeah? Because that's when Marcy went on the air and made his hostage statement, right? Let's go to the chat, see how everyone's doing. Kathy became a member, welcome. Chop Saws became a member, welcome. June, thanks for your super chat. Since Mr. Bederow is the attorney in Turtle Boy's case, should he already be allowed to try a case in Massachusetts, or it's case by case? It is case by case. It is case by case, but it helps if you've been admitted pro hoc vice in Massachusetts and other cases. That works in your favor, but apparently not in this case. But yes, it is on a case by case basis. So every time you want to represent a client, you have to apply again and be sponsored by an attorney of record. Thank you, Alessi's Cross Punch. More droppings on top. Thanks for being on top of the super sticker. Thank you so much for loving my show, Samantha Jones. And I love you. And she says she loves that I stopped to explain and to vent. Yeah, today's not a good day. Today's not a good day. Today is not. It's not Fun Day Friday around here. Casey Cat, welcome. Tracy Walker gifted another 5 memberships. Thanks, Tracy. K-Wags is thanking me. Thank you. If we weren't all crazy, we would go insane. Jimmy Buffett said that once, didn't he? Thank you for your super chat. Jennifer Miller, I love when Melanie says I will allow it. Thanks, Melanie, for being so cool, calm, and classy. I'm not calm today. That must have been, this is an old super chat. I'm behind, as you can tell. Thank you, Jennifer Miller. KZ, the pig DNA found on John O'Keefe is from the dog treats fed to Chloe. Defense needs to hire dog food expert. Sorry, I know another expert, but quite important. No, I know that a lot of people think that, but I'm going to say to you that if there's pig DNA found on the clothes, don't you think there would also be dog DNA found on the clothes? So I don't really like that argument. I don't really like the argument that it was dog treats. I think pig DNA is because the butcher paper was used, just like the Solo cups were used and the Stop and Shop bag was used. Maybe they found the butcher paper inside the Stop and Shop bag where someone bought pork sausages. So yeah, a lot of people have brought that up. I don't really like that argument. You know what I mean? Because if there's pig DNA, why wouldn't there also be dog DNA? It just doesn't, I don't know, it doesn't make sense. Did Hank file his court TV proof, or did he correct the record on Yannetti? He corrected the record on Yannetti being on court TV. So we'll look at that in a sec. But thanks, Amy, for asking. But we still have that to get to. Thanks for your time. Is Bev questioning Bederow's ethics? Well, kinda. I've never seen a pro hoc vice application denied before. And I don't even remember. Did we even look at Yannetti's supplement? We did. Did we look at her order yet? I don't know if we did. So we're going to have to look at the order. Did we do the order? I'm all confused. Because I think we were reading Yannetti's papers, supplementing the record. Then we jumped to the order for sanctions. And now we got to go back to the order where she doesn't allow Bederow, right? I don't know. Somebody help me. My head is going to pop off. Samantha says, believe it or not, because of this case and the way the state is, I am moving this month to another state. I'm done with Massachusetts. Oh, Samantha Jones, come to New York. It's Sex in the City. Thank you, Bella Brat, for thanking me and for your super chat. Would you explain what a motion in lemonade is? Yes, sure, I will. Thank you for your 20. A motion in lemonade is what the closed captions one day called motions in limine. Motions in limine are pretrial motions made by either side to either to get a ruling on evidence as to whether they want it admitted or excluded at trial. so that all of these things are decided prior to trial. For example, I think that we can expect such motions in Lemonade as excluding the blood alcohol level of Karen, because we saw that motion before the first trial, because the blood wasn't drawn for the specific purpose of blood alcohol testing, because the witness from the Massachusetts State Police Crime Lab came on the stand and testified that that's not the reason that they draw blood. That's not the proper test to be done for that. He doesn't know when her last drink was. And so therefore the results are faulty. Things like that. Things that you don't want to come into evidence, or things that you do want to come into evidence, and you want to get all those things decided ahead of time. So there's going to be a lot of them coming, and we're going to be going over all of them. So it's going to be real busy around here until April 1st, when jury selection is supposed to start. But I don't know at this point if it's going to happen, because especially now that Brennan wants an extension to March 14th to do his motions in Lemonade. Glamassus, thanks for the $5. Brennan spent lots of time in lockers in high school. Donate to Karen. She needs the money. My money from Dubai came in, and I'm donating $250 to Karen. That's so very nice of you. Thank you, Suze. The whole world calls me Hanks. Thank you so much for the 50. Since she denied Bederow, I expect she will allow the gag order, the sanctions, and anything else the prosecution wants. Then she will remove Jackson and Little off and leave Karen holding the bag, right? Time to file to have her removed. Thank you so much for your 50. They did make a motion to recuse before the first trial, and we read the decision again recently. I remember it was a Saturday. I remember I was in California when I read it to you, so I don't remember exactly the date of it. Will she recuse herself again, Hank? That's the $1 million question. I think not. Thank you so much for your very generous super chat. Auntie Shell says she loves hearing me go of the papers. Thank you. We are outraged. Borders girl, is it just me, or have they all grown awfully bold since announcing the feds are gone? I want to believe that was the plan by the feds, but I know better. It's just you. Craig, anyone here think it's a coincidence that they denied the pro hoc vice, the attorney that specializes in Rule 14 issues and police misconduct? No? Yeah. We're going to look at her reasoning for that in a sec. Bev's White Claw, thanks for the 10, says, this is BS, but I hope now he will be back with you on YouTube. I did reach out to him. Like, dude, does that mean you can come on and yell with me? But I'm sure he's very, very, very busy. Very busy. And angry, and probably not the best time to come on YouTube. And you know, I don't know. But I know that Jackson and Unetti can't come on because they're gagged, but they've never come on anyway, and I would never even ask them. Great point. Thanks for the 10. Melanie, you do you. It's your channel. Thanks, Jessica. Mama Sheep, please don't go. Love you too. Thanks for the super chat. Sue says, I'm just about in tears at this point. Tired and frustrated. Karen is not being given a fair trial as guaranteed by the Constitution, sending hugs. Well, wait until you see what I dug up on Coleen, Crawford, and Fanning. We're going to get there. I promise. Thanks, Val, for becoming a member. Bella Brat, you just need a good concert and some good music, Melanie. We love you and appreciate all your hard work to help us get through this. Thank you. I know I do. I really do. I need to set the reset button of life. Here I come. Dead and Company, here I come. Kelly, if Chloe you must have quit. Thank you for all you do. We appreciate you so much. Unduck Unbelievable. Physically nauseous over this injustice. You're not the only one, Kelly. And your feelings are valid. And thank you. This is a place for you to vent with me. I'm here for you. Paisley Chicken, I got to leave for an appointment. We'll return for your replay. I absolutely love your silent commentary. Oh, that is so very sweet. I'm trying to inform the public. Everyone needs to know about this. When I started talking about this in January of 2024, I don't know that any other law tubers were covering it. I don't know. I mean, I know that there's people that, you know, like Will the Glairer and probably the Young Jerks and other YouTubers that were covering it. I don't know if anybody on LawTube was, and people were afraid to. And really, quite frankly, based on what happened to me very quickly in the cesspool of the social media, being personally attacked and doxxed and all kinds of things, I'm not surprised. But I'm glad that everyone's talking about it now, and I'm glad that all the lawyers are outraged, and I'm glad that the world is watching, because you are the eyes of the world. Karen says, Beverly has a brass neck. What a witch. Thank you. Deja Vu Trial 2 says, please don't quit. You are our go-to. Love your coverage. You know, it's hard. It's hard. Thank you. Thank you. Julie James, thank you for your super sticker. Casey Cat, is there any way to appeal to a higher court to have her recused? Well, they would have to have an order to appeal. And I just looked up the guidelines in Massachusetts, then the rules on interlocutory appeals, which are appeals that are allowed to be taken before the case is finalized. And they're very slim in Massachusetts. And unless it's evidentiary, there's really no other road to an appeal until after all of this is over. So no, unfortunately, no. Can they appeal the Bederow being denied? I don't think so. I don't think so. There are examples of blatant bias. We all be stone cold alcoholics before this is over. I know, right? Anybody who's sober, please, please, please stay strong. Stay strong. Michelle Monaghan, I don't think I have the energy and mindset for this next trial. A lot of people have said that. A lot of people have said that, but I ain't got no quit. I say, I get upset sometimes, but I ain't got my quit. It shows no one above the judge, and I use that term loosely, cares about justice either. I'm with you, girl. I'm with you. Sarah says Sarah says that I'm the best. Ignore the stupidity. We appreciate you. XOXO, Sarah and Liz. Thank you, Sarah and Liz. I love you even more than you love me. Angie's Wave, the shoe is on the hand. It fits. There's really nothing much to it. Whistle through your teeth and spit, because it's all right. We will get by. We will survive. Angie's Wave coming in with the hot take on the Grateful Dead lyrics. Thank you so much. Tammy Walker, I think yesterday's filing was written last year, but he waited to file it at the last minute. That's why the dates are in the past. You know what, Tammy? I'm tired of making excuses for that guy. I think his paralegal hates him. I think she's just writing over like other motions and it's like scratch and sniff. You're probably right. I'm being funny or trying to be because we got to laugh sometimes, but somebody put a comment in yesterday that paralegal hates him and I'll allow it. Pella Bradford, you with $100 super chat. You're so sweet. For Melanie and Mods, thank you so much for all you do. This chat loves and needs you. The snark tank is alive and well. Never doubt the snark tank will handle any and all trolls. Thank you. It's really super generous of you and never necessary, but I do appreciate it so much. P. Kitty, we love you. Take a mental health spring break with your family. If that will help you, we will be here. Thank you. It's like there's just so much every day. There's so much to cover on this. It's really, and it's never anything that's like good or positive. And the bias is so blatant and the corruption is so blatant and the doctoring and proctoring of evidence and inverted videos and Brady violations. And like, when are we going to get a grip? When is somebody going to get a grip? Like, see what's going on here. And when the judge said that she had no evidence of 47 pieces of taillight, where did that come from? I really thought my head was going to pop off. I know I say that a lot. Really, Judge? Really? We're going to look at the supplement to the record that Yannetti had to do because she asked for all those things like proof of 47 pieces of taillight because she just didn't remember. Just south of history. Thank you so much. Your tweets are amazing. You're so funny. It says, everybody in Mel, we love you. Please remember this. It's always darkest before the dawn, and God always does his best work in the worst moments. Love each other. That's such a great reminder. Thank you so much. Midnight Mike, thank you for your super sticker. Prestige Worldwide. Hey, girl. Hey. I know you've been away for a while. Thank you so much for your super sticker. Midnight Mike is gifting 5 memberships. You're the greatest. And yeah, better with the Irish. Listen, she says this makes it hard to continue 7 years of not drinking. You could do it. One day at a time, you could do it. It's not worth it. It's not worth giving up 7 years of sobriety. Everybody give better with the Irish. A non-alcoholic slancha to make it through because you worked really hard. Don't let this duck it up for you. Climate Sues, the denial of Pro Hoc VJ is considered a final decision and is appealable on an interlocutory basis. Bev may have sank her April 1st date. I can't confirm that. The rules of Massachusetts, in my opinion, do not support that. So if you have another source for that, other than the Massachusetts Rule of Criminal Procedure on interlocutory appeals, which is Rule of Criminal Procedure 15, Criminal Procedure Rule 15 on interlocutory appeals, I mean, I'll hear it. But I'm not seeing it there. So thank you for the 5, but I don't know that that's true. She's entitled to counsel. And when we read her decision, which we're probably just going to do now because we've been trying to avoid it. When the other thing popped off. Random Thought says, I've actually been popping bubble wrap from a book I received today. That is so fantastic. I love that. I love that. I'm going to get out with that magic 8-ball because I'm trying to pop, just pop, stay calm, pop, 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 pop. That's fantastic. I love bubble wrap too. Has anybody tried putting Massachusetts in rice? Maybe unplugging it and plugging it back in. That's why I love you. That's why I love you. You guys are amazingly awesome and funny. And you try to keep laughing. And I thank you for that because I need all the help I can get today. Nick Starro says, I know Brennan lied, but I will take his word for defense misconduct anyway. Yes, of course. Of course. And you know what else, Nick? He doesn't have to put anything in writing. He can get up and say whatever he wants and pretend it's true. And it is absolutely insane. It is insane. I know you're outside the country, but if your head is popping off too, where are we? How did we get here? Meeple Marcy, what about the miniseries already set to come out on Discovery ID or HBO? That's a great question. What about stuff that's in the can, as they say in the biz? The stuff that's in the can. Are they allowed to release it if it's got Alan Jackson and David United speaking on it? Does it have to be heavily edited? It could be a problem. Did Lally talk to them? Did Brennan talk to them? I mean, that's a great point. I don't think they're very happy inside the production offices right now. Right. 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 Okay, so let us go to the motion, the order. We read the supplement, right? And the last paragraph of that I rushed through in my hissy fit was on February 18th, 2025, the Commonwealth stated that it did, this is United's papers. The Commonwealth stated that it did not object to Mr. Bederow's admission pro hoc vice or to the defense providing additional information to this court ex parte before the court decided on the motion. Wherefore, please grant the motion, Judge. And that was dated yesterday, March 6th. It was not, I think, put in the record or in the docket until today. Now, we need to go to the judge's order on Bederow because we did not get there yet. Yeah. So now we need to read her reasoning for denying him. And that, my friends, is here, and it's short and not so sweet. This is the court order, decision and order on defendant's supplemental motion for admission pro hoc vice of Mark A. Bederow. After review of the pleadings, the defendant's supplemental motion for admission pro hoc vice of attorney Mark Bederow is denied. The quote, in quotes, affirmation submitted in support of the motion is insufficient on its face. In addition, the proposed concurrent representation involves a conflict of interest that is not waivable under Massachusetts rules of professional responsibility. See Massachusetts Rule of Professional Responsibility 1.7a and b. See also comments 22 and 23. One such conflict is specifically outlined in the motion at paragraph number 8, where Mr. Bederow, apparently speaking through Mr. Yannetti, promises to restrict his use of certain information. The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation of the other client. I don't know what they call it now, but I'm so old that when I went to law school, they used to call it a Chinese wall. And it used to be, you could build a Chinese wall around someone in the office if they had a conflict and the rest of the firm didn't, so that that person would be like protected by this Chinese wall, and you could protect the conflict. I don't know what they call it now. What do they call it now? Uncivil? I don't know. So they did not attach an affidavit of Mr. Bederow, but they did say he is available. Would you like to speak to him ex parte? You are free to call him in. He is ready. He's here. He's here most of the time anyway, because he's in the building. He was in the building, whatever day it was that we did the last hearing. He was in the building, I think, yesterday for Aiden Carney's hearing. So he can come in and talk to you. Chinese water torture did come up in Aiden's hearing. That's right. Now it's called an ethical wall. Thank you, Hope Martin. Hope Martin, who is probably maybe Gen Z attorney or is in law school now even, which would make you, no, that's Gen Z. And then there's millennials. I don't know. It's an ethical wall. Okay, cool. Thank you. Ethical wall. A lot of people knew that. I'm old. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by admission pro hoc vice. XOXO. Order, defendant's supplemental motion for admission pro hoc vice of Mark Bederow is denied. XOXO, dated today, because she already had this drafted, I think. Maybe. Beverly Cannone, Justice of the Supreme Court. XOXO. See what she's doing here? You see what she did here? You see what she did? Anybody catch it in the last sentence? She's already got enough lawyers, and you know what? I've already extended you enough courtesies. By granting 3 pro hoc vice attorneys. I didn't know there was a limit. 3 as in like 3-card Monty. I mean, I admit it was a long time ago when I went to law school. But if clients are schooled on the conflict, given the opportunity to consult with their own counsel, and they waive the conflict in writing, is this a waivable conflict? I am not. There are attorneys that specialize in ethics, and that's what they do. They represent attorneys who have to go in front of the bar of board overseers, who have to go in front of the grievance committee if you're in New York. And that's what they do. They specialize in ethics. They specialize in getting attorneys out of being disbarred, or at least trying to, push for a lower sanction than disbarment, like a suspension or maybe a public tongue lashing. But here she says, Massachusetts Rule of Professional Responsibility 1.7. We're going to have to look it up. 1.7. Well, is it the model rules of professional conduct or the Massachusetts rules? I'm going to have to look at the Massachusetts rules, I guess, because that's what she's looking at. So the first thing that comes up when I put in Mass RPR 1.7 is screening for syphilis infection recommendation statement. Like, you can't even make this up. It's screening for syphilis. Okay. Syphilis has entered the chat. And of course it has. Massachusetts rules of professional conduct. You can't even make it up. Responsibility. I spelled it right. They just didn't like those initials. All right, here it is. Conflict of interest. Let's take a look and see what she's talking about. She's talking about 1.7 A and B in comments 22 and 23. So that sounds right. I mean, you can't make it up. Bye-bye. I'll move you over here and I'll move you over here. One of these days, Spanky, one of these days, I'm going to figure this streaming thing out. It's going to be glorious. It's going to be glorious. Here is the rules of professional conduct, rule 1.7, conflict of interest with current clients. And what did she tell us to look at again? I have to go back to her. She says 1.7A and B. A, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if Cusco says, just Cannone should order the syphilis testing also. A concurrent conflict of interest exists if one, the representation of one client will be directly adverse to another client. Well, I don't see that here. Or, so that's an or, not an and. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person by a personal interest of the lawyer. Well, I don't see that here either. And here's why. Didn't we just read a motion? And I'm conflating everything in my head now because there is so much information like attacking us at once. Didn't we just read a motion where Spanky wants to get, and it is, we should call him Spanky because it is like the little rascals here. And does that make Lally alfalfa? It kind of does. You know why? Because of his little shark, his little baby shark hairdo. Remember his baby shark hairdo? It was like when your little baby's in the bubble bath and you make that little shark fin on top of their heads. It's the little rascals. That makes Laura McLaughlin Darla. Didn't he just ask for all of Aiden Carney's phone records from the Commonwealth versus Carney case so that he could show consciousness of guilt on the part of Karen Reed because the two of them were in cahoots to intimidate witnesses in her case? Doesn't he want to use Aiden Carney's phone records to show consciousness of guilt? So how can they be adverse? How can they have adverse interests if the Commonwealth is asking for his records because they're in cahoots? If they're in cahoots, they don't have adverse interests, right? Am I explaining that correctly? Right? Okay. So that's 1.7 A and B, and that's what she's hanging her hat on here. And then she says also comments 22 and 23. Like you can't use it as a shield and a sword. You can't have it both ways. Here's section B. Notwithstanding the existence of a concurrent conflict of interest under paragraph A, the lawyer may represent a client if 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. Well, he said that, but he didn't say that directly. Yannetti said it for him. Maybe that's her problem. And that's why she's saying that it's insufficient on its face. It's facially insufficient because Bederow didn't swear to anything. But how can he support anything? How can he submit anything if he's not admitted pro hoc vice in this case, right? You can't use that as a shield or a sword either. You can't have a lawyer who's not admitted pro hoc filing papers in this case. See the catch-22 there? Yeah, Little Rascals and Syphilis all in one stream. You get it all here. You get it all. Chloe's mom, you get it all. It's comedy. It's law. It's snark. It's outrage. It's tears sometimes. You never know what you're going to get. Life is like a box of chocolates. It's like a box of chocolates in here. You never know what you're going to get. Hit the thumbs up, folks. Yeah, there's only 7,039 people here. You can do it. I know you can. It is biased against the Commonwealth because they deserve a fair trial too. Yes, I know. I know. All right. So notwithstanding the existence of a conflict of interest, a lawyer may represent a client if the representation is not prohibited by law. It's not prohibited by law here. So cross that one off. Cross off number 1 because he does believe that he can be able to provide competent and diligent representation to each affected client. And 3, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. So they have their interests are aligned, right? So I don't see that here. And each affected client gives informed consent, confirmed in writing. Well, they have that too. So is the judge saying that she needs to see their signed consents? That's work product. She's not entitled to that. I think Yanetti's representation is enough here. I think her decision is wrong, according to the ethical rules that she herself cited. But let's look at comments 22 and 23. Don't get dizzy. It'll be over soon. Well, no, the trial won't be over soon, but me scrolling will be. Comments 22, consent to future conflict. Whether a lawyer may properly request a client to waive conflicts that might arise in the future is subject to the test of paragraph B. Oh boy, why do they got to make things so confusing? The effectiveness of such waivers is generally determined by the extent to which the client reasonably understands the material risks that the waiver entails. The more comprehensive the explanation of the types of future representations that might arise and the actual and reasonably foreseeable adverse consequences of those representations, the greater the likelihood that the client will have the requisite understanding. Thus, if the client agrees to consent to a particular type of conflict with which the client is already familiar, then the consent ordinarily will be effective with regard to that type of conflict. If the consent is general and open-ended, then the consent ordinarily will be ineffective because it is not reasonably likely that the client will have understood the material risks involved. On the other hand, if the client is an experienced user of the legal services involved and is reasonably informed regarding the risk that a conflict may arise, such consent is more likely to be effective, particularly if, for example, the client is independently represented by other counsel in giving consent. Well, they were represented by counsel before they signed their consents. And so therefore, I'm going to just yeet this because it doesn't even apply. Okay. And quite frankly, I don't know that she can decide this on the law. Let's just look back at her decision. Hang on. Oh, yeah, of course. She doesn't cite any law. She doesn't cite any cases in her decision and order, because this is probably not in accordance with any case law. And so I think it's just like you have enough lawyers already, Ms. Reed. I've already admitted 3 pro hoc vice, so that's enough. Is something funny, Ms. Reed? And then she also says we should take a look at comment number 23. Conflicts in litigation. Paragraph B3 prohibits representation of opposing parties in litigation regardless of the client's consent. Okay, well, they're not opposing parties. On the other hand, simultaneous representation of parties whose interests in litigation may conflict, such as co-plaintiffs or co-defendants, is governed by paragraph A2. Well, they're not. Conflict may exist by reason of substantial discrepancy in the party's testimony, incompatibility in positions in relation to an opposing party. I don't see how such conflicts can arise in criminal cases as well as civil. The potential for conflict of interest in representing multiple defendants in a criminal case is so grave that ordinarily a lawyer should decline to represent more than one co-defendant, but they're not co-defendants. And the grand jury failed to indict that ham sandwich, so they're not going to be, unless the judge knows something else that we don't know. Or more than one person under investigation by law enforcement authorities for the same transaction or series of transactions, including any grand jury proceeding. Well, he doesn't have any knowledge of that. On the other hand, common representation of persons having similar interests in civil litigation is proper. Well, this is a criminal case. And so those are the 2 comments that she wanted us to read. And is she right on the law? I don't think so. Is a defendant entitled to the representation or counsel of her choice? Yes. Isn't that in the Constitution? Does the judge have wide judicial discretion, and is she the gatekeeper to hell? Yes. Yes, she is. Would she maybe have wanted to talk to Mr. Bederow to allay her fears? If by facially insufficient, she means that Bederow can submit an affidavit and she'll reconsider? I don't know. But let's go to the chat because I don't like this decision. But of course I don't, because I never do. I never like any of her decisions, except for I thought it was nice that she didn't give them sanctions. But you know what that is? That's like the little, it's like the little, back rub before the smackdown, maybe. And maybe she's like, okay, I'll give you no sanctions, but I am going to disqualify Alan Jackson and pull his pro hawk status. And with him goes Ms. Little, because that, remember, is the motion on ARCA, not the sanctions motion. So that wasn't decided today. Let me refresh my browser, see if anything else, other droppings happened, but I don't think so. Pam says, I need you to read these to me, Melanie. I would wait all night for you. Thank you. Thanks for your chat. Nurse Kel, thank you, says nothing about her uncle who can't shut up. Whose uncle? Does Judge Cannone have an uncle? The Goodmans are here. They can get to the membership. Hey, guys, love you. Emily says, Auntie Deb and the Young Jerk said Hank Brennan is like Eddie Haskell from Leave It to Beaver, and it's so true. Don't be hating. Can proving information is exculpatory and important to a case, can it override a protective order? No, not necessarily. No, they can't. I mean, there's certain stuff. I mean, that's why there's motion. You mean to not. So the protective order just means that it needs to be sealed from the public in the court file, right? That's what we're talking about now. And so having it come in at trial is something different. And so that would be a subject of a motion in limine. Deja Vu Tratu says, sorry for the rough day. Please enjoy your weekend. Thank you so much for your 20. I appreciate you so much. Abacus Flinch, since none of the lawyers in this case can comment on this, how much you want to bet there's another hostage video from Norfolk County going to happen before the end of the month? No, he can't. Marcy can't comment either. So he's part of the district attorney's office. He's part of the parties in this case. He is the Commonwealth. He can't. Thank you for your super chat. Deborah, is it true you can say what you want to press, but since you're not under oath, it can't be held against you? It can be used as a statement. No, it can. If you're a criminal defendant, it can be used as a statement against interest, and the jury can hear it. And the only way that you can dispute it and say it's not true is to take the stand. So I hope that answers your question. Thank you for your super chat. Pauline, wouldn't her blood alcohol level be considered fruit from a poisonous tree? Well, she was admitted to the hospital under a Section 12, which is an involuntary hold in Massachusetts, because I think for whatever reason, they thought she was a danger to herself. And so they drew her blood pursuant to that. I think the better argument is that it's not reliable because they don't know when her last drink was. She could have went home after dropping off John and drank a bottle of vodka because they didn't draw her blood until like 9 a.m. the next day. So there's that. Thanks, Pauline. Brenda, forgive me for not remembering the legal term, but couldn't Karen request a stay and have a court investigate Bev for being biased and have her removed? No. Only certain things will stay a criminal trial. Sometimes an appeal will, if the appellate court decides to agree to take it up. But no, there's no court that's going to investigate her. It's not like they can file a complaint and have somebody investigate. It's just not how it works, unfortunately. But thank you so much for your super chat. I appreciate you. Bobby Leslie's linguistic prowess. Thanks for your 50. So I know that you don't agree that people should report Judge Bev to the CJC in Massachusetts. I can't support that as an officer of the court. It's against my own ethics to even put this comment up and even encourage anyone to do it. No, I would not encourage it. I would not. Thank you for your super chat. And I should have read it before I put it up. But I have a code of ethics as a practicing attorney that I too have to abide by. And that is not something that I can encourage, support, publicize. But I do appreciate your and again, thank you again for this super chat. What the duck? Maybe the pig DNA is from the pizza man. Well, they're saying also he had potato skins at the bar, right? With bacon on them. I don't know. I think that's a better argument than dog treats, right? Pepperoni's made of pork. Yep, exactly. Thank you so much. If only someone tested the random DNA found on Officer O'Keefe, right? Wasn't there also 2 other contributors to the taillight DNA? and 2 other male contributors to the red-brown blood stains on his jeans. We don't know who they were. Oh, Mindy, thank you so much. That's okay. I don't no, don't worry about it, sweetie. Thank you. I appreciate you so much. Yeah, it is. It's only fitting because, it is what it is. Careful, Bev. Your bias is showing, says Chastity. John Monaco, we need you to help us navigate the madness of this crazy persecution. We are outraged. We all are. Try some shine down for some music to get you going. Thank you. Witch in the wardrobe. Sending love and positive energies. May we all find our way through this with the same strength Karen has shown. We love you, your mods, and appreciate so much more. Thank you. Thank you. Thank you so much. Back to your wardrobe. You go. Back to Narnia. You're off. Mama Shay, please don't go. Don't go away. Please don't go. Insert music notes. I don't know which song. I can't think right now, Mama Shay, and I love you, but I can't. Please don't go. I mean, it's just not coming to me. Whether interlocutory appeals are few and far between, says Bobby Zalez, using linguistic prowess, the defense should still pursue that. Getting a grip is standing up for justice. Hold, please, 1 second for me, if you don't mind. Thank you so much. Let me just say that it is not a smart thing for attorneys to do to file motions that could be considered filing in bad faith, or if they know they don't have a basis to. And listen, I think we can agree that they're already like on thin ice, right? Bederow's not being allowed in. We still don't know if Jackson is going to be allowed to stay on. And so, I don't know. But I'm going to pull up. I thought I had it open on here. Oh, I do. All right. So this is Criminal Procedure Rule 15. And because every jurisdiction is different and I practice in New York, I don't want to tell you the information unless I have the receipt to back it up. So let's take a look at it. Captain Trips is here. Now, my mama told me, my papa told me too. Well, I should be here trying to sing these railroad blues. That's another Grateful Dead reference, and I love it. Thank you so much. All right, let's take a look at the rule on interlocutory appeals in Massachusetts. An interlocutory appeal is an appeal that happens before the case is over. And this is specific to criminal cases. It says, right of appeal where a pretrial motion to dismiss or for appropriate relief is granted. So if a motion to dismiss is granted, then you have a right to an appeal. But you don't have a right to appeal if it's denied. See how that works? Because it's got to be fair for the Commonwealth, not the defendant. It says the Commonwealth shall have the right to appeal to the appeals court a decision by a judge granting a motion to dismiss a complaint or an indictment. Number 2, right of appeal where a motion to suppress evidence is determined. So if it's evidentiary, then a defendant or the Commonwealth shall have the right and opportunity to apply to a single justice of the Supreme Judicial Court. And that's what happened in the Rule 17 motion before the first trial to obtain the cell phone records of Jennifer McCabe and Brian Albert. It was denied by Judge Cannone. They asked for leave to a single justice of the SJC. The SJC took it on and they overturned it in part. And the defense was given Jennifer McCabe's. I will. Nope, I haven't talked about it yet. It's coming. It's coming. Thank you for reminding me. I mean, I knew. I'm getting there. I know this is a lot. So that you can appeal before the final trial as an evidentiary issue, or where a delinquency defendant is discharged. And it says no interlocutory appeal or report may be taken of matters arising out of a probable cause hearing. So that's it. Those are your very slim grounds. A motion to dismiss being denied is not a reason. It's not a reason. And it doesn't say that a denial of pro hac vice is a reason either. All right. Let's get to it because you guys wanted to hear about it. So here's the thing. So many of you pointed out and were putting on Twitter, and so many of you sent it to me. So many of you sent it to me that it may be that Coleen Crawford and John Fanning were in business together and they had a business together and they dissolved their business together like right after John O'Keefe was murdered, like February 2nd, like 2/2/22. Hang on. There was a case. There was a case in, I think it was 2015. Does anybody remember a case out of Quincy? There was a man named Paul Fahey who beat a fellow bar patron to death in a bar called Home Ice Sports Bar in Quincy Center. Paul Fahey murdered a man named Keith Bourdreau. Does anybody remember this? Does it ring a bell with anybody? Yeah, that was like the day after Karen was arrested. Yes. Anybody remember this case? The murder of Keith Bourdreau. Home Ice Sports Bar, now defunct. It used to be in Quincy Center. Paul Fahey, 44 years old, was due to head to trial this month, which was back in 2017, for the murder of 42-year-old Quincy resident Keith Bourdreau. What had happened was Fahey, who was 280 pounds, suddenly punched Keith Bourdreau in the face and later stomped on his head with a heavy work boot and basically stomped him to death. Yes, stomped him to death inside the bar. And then the owner of the bar said he was scared of this guy and helped him drag the body of Keith Bourdreau out to the back alley of the bar through the back door. This was back in March of 2015. And then what had happened was the bar owner, his name was DeLuca, called the police and told the police that he found a drunk man in his rear parking lot. But then it turned out that this guy DeLuca helped drag him out there because he says he was afraid of this guy Fahey. So Fahey went to trial in 2017. It says here, the witnesses told the grand jury that the force of the second blow knocked Bourdreau 6 or 7 feet across the bar and onto the floor, where he was still lying some 20 or 30 seconds later when Fahey stomped on his head with a heavy work boot. When the bartender, Kerry Sullivan, screamed for someone to call 911, Fahey told her, "Don't call 911. Don't you dare call 911," according to her testimony. Another patron at the bar, Keith Anderson, told the grand jury that the whole thing was like something out of The Sopranos, HBO's mobster drama. "I went there for a beer and I ended up in a murder trial," he said. And so he was convicted of first-degree murder. And then I think his conviction was overturned because of prosecutorial misconduct, because the prosecutor called him a bully in closings like 5 times. And I think he's getting a new trial. Okay. But here's what I found interesting. Because of this case, there was a civil suit, of course, as there often is in wrongful death cases, right? And in the civil suit, there were some motions that I found because, call me Alice. I went into the rabbit hole. And this might blow your mind. It might not. Maybe somebody already found this and put it out there on the cesspool Twitter. Many of you I know are not even on Twitter. So when I say no spoilers, it's for the benefit of the people that are not on Twitter. And many of you I know are not. You don't like to play there. Are you ready? So this is in the civil suit. This was filed in March of 2020 in Norfolk County Superior Court in the civil suit. It's the estate of Keith Bourdreau versus Paul Fahey and other defendants. Ready? Defendant Paul Fahey's motion for an order to the Norfolk District Attorney's Office to produce to Fahey all unedited documentary and video records in their possession in the matter of events occurring at the Home Ice Sports Bar in Quincy, Mass. On March 23rd of 2015. You may need to pour yourself a drink. Pro se defendant Paul Fahey respectfully requests this honorable court allow this motion and order the Norfolk District Attorney's Office to produce to him all unedited documentary and video records in their possession in the matter of events occurring at the Home Ice Sports Bar on March 23rd of 2015. He's pro se, which means he's representing himself, which means he must have a pretty good courthouse lawyer, jailhouse lawyer. And he doesn't have anything anyway. So he's like, good, get a judgment against me. Well, what does it matter? I'm sitting in prison right now. This honorable court allowed a similar motion for an order directed at the Quincy Police Department on February 12th of 2020. That's my birthday. The Quincy Police Department followed the order, but was only able to produce limited records. Apparently, the Norfolk DA's office received the bulk of the unedited video surveillance transported there by Trooper Fanning and Coleen Crawford, as Exhibit A shows. These records, there's a blank page in here for whatever reason, have paramount relevancy to factual determinations in this civil action. Though Fahey was at one time provided with surveillance by the District Attorney's Office regarding a criminal investigation into events occurring on March 23rd, 2015 at the Home Ice Sports Bar, these videos and documents were heavily edited by the sure hand of counsel for the District Attorney's Office. This means that the records were curated rather than raw, generating questions of accuracy. Did anybody's head pop off yet? This is from 2015. 2015. Olivia, did you know this? But in the civil session, where the District Attorney's Office is not a party, it is contrary to the truth-seeking character of the Superior Court to limit the record to evidence that the District Attorney's Office finds relevant. That is, the complete record must be produced unedited and raw. This will benefit the fair adjudication of this case like metadata. Finally, Fahey notes that the other parties to this action agreed to this motion for an order directed to the Quincy Police Department. There's no reason to believe they will contest this motion. Here's the proposed order. Listen to this. This is the police report from March 29th, 2015. It's a supplement. It was approved. On Friday, March 27th, 2015, at approximately 3:50 p.m., Detective Tom, I'm not even going to try and pronounce this, Pepdajanovic, and I, Detective David Pacino, because of course there's got to be a Pacino in here somewhere, along with Trooper John Fanning and Coleen Crawford, Norfolk County Multimedia Director / Forensic Video Analyst, traveled to the Home Ice Sports Bar at 35 Washington Street to retrieve surveillance video pertaining to the incident that occurred on Monday, March 23rd, 2015. Upon arrival at the Home Ice Sports Bar, we had the opportunity to meet with Gerard DeLuca, the owner. He's the owner who helped drag the body out. We advised Mr. DeLuca as to the reason for our visit, and he accompanied us downstairs to his office where the surveillance system is located. But of course it is because, isn't the office always in the basement? We advised Mr. DeLuca as to the reason. Oh, yeah. All right. There we go. Detective Pepdajanovic presented Mr. DeLuca with a Quincy Police Department consent for search form, which was subsequently signed and dated by Mr. DeLuca. After obtaining verbal and written consent from Mr. DeLuca, Coleen Crawford attempted to download the surveillance video of the incident. Due to the age of the surveillance video system, Coleen Crawford was unable to retrieve the surveillance video It was determined that Colleen Crawford would need to secure the surveillance video system as evidence and perform forensic video analysis at the Norfolk County DA's office in Canton, Massachusetts. At this point, the surveillance video system was secured as evidence and transported by Trooper Fanning and Colleen Crawford to the Norfolk County DA's office in Canton, Massachusetts. The completed Quincy Police Department consent for search form was submitted to Detective A.J. Carthus. Respectfully submitted XOXO. Detective David Pacino. Well, seems that there was some doctored video, surveillance video, in the murder case of Keith Bourdreau as well. Paul Fahey, Trooper Fanning, Colleen Crawford had their hands all up in it all the way back then. And I haven't. And maybe, just maybe, this is how deep the tentacles go. Right? Maybe, just maybe. But exactly. Fanning has an unblemished record, according to Hanky. Right. And you know what they're going to say? Paul Fahey's a convict. He's a prisoner. He was also in a motorcycle gang. We can't trust a thing he says, but Fanning is an impeccable, unbelievably wonderful prosecutor. Who was the judge in the first trial? That's a great question. I'm sure somebody can Google that faster than I can. Because what I have here is the Patriot Ledger article that says that the trial is about to begin. So I'm sure you guys can Google it, fall into the rabbit hole, do the things and stuff, and you can figure it out. But methinks this may have a long-standing history. And I'm not in Massachusetts, so I can talk about it. What say you? Mike Dorado is here. Thank you for thanking me. He's sick to his stomach. It's okay. It's okay, because you know what? I fell in the rabbit hole, Mike. Might have cracked the case. Bone says, can a defendant get a court order so Dr. Russell can examine Chloe? Dr. Russell's not like equipped to examine Chloe, right? That's not her thing. That's not her specialty. It's wild to me that Crosby is allowed in on papers and Dr. Russell sat through a 2-day voir dire. Ms. Holmes says that I resemble Kim Cattrall. Oh, I'll allow that. Thank you. Jazia says, please add a free Karen Reed bucket to your merch for a popped off heads. That's so great. Good idea. Couldn't stomach this without me. Love the cupcakes. Thank you. Alibi McCabe is here. We ain't got no quit. Thank you. Amora Valesa, your frustration at people rushing you reminded me of my poor dad. Anytime we were waiting for a green light and my 2 brothers and I would scream, go! Oh, my kids do that too. Before his foot could even move to the gas. I know. It's a thing. It's a thing. Curious, would we be able to create a petition to pardon? So somewhere we can plead with that and jump over? No, because, I mean, who could pardon her? The governor, but she hasn't been convicted of anything. So I don't think there's a pardon, but that's a good random thought, I don't think she'll ever be convicted, but I've been wrong. Interlocutory appeals are a right a criminal defendant has. It's different in a civil case, but not criminal. I know we just looked at the criminal rule. Did I misinterpret the criminal rule? Because I thought I got a good grasp of it. Bias Bev uses the magic 8-ball to rule on motions. I think you're right. Could be. I don't have any energy left. Sorry, D. Sorry. Shay Godin, have you had any thoughts about joining the defense team? No. No, I'm perfectly happy sitting in my home studio talking to all of you. No. Absolutely not. Karaoke, this is insane in the membrane. Yeah. Thank you. Does the gay order apply to both sides? Yes, it does. That means Michael Marcy cannot speak either. And so thank you, Lisa, for your super chat. Bev's rules are the rules. Yep. It's her world. We're all just living in it. Kirsten, you know it. My cousin Vin, taking a moment to tell me how much you appreciate me. Oh, I appreciate you more. I appreciate you more, Vin. Thank you for your super chat. Dr. Russell is the goat, is here up from Norway. Says you're not allowed to share any info under seal, said the judge who shared the info under seal. Right? Of course, right. Appreciate your Walsh coverage earlier. Thanks for your time and interest. Thank you so very much for watching that one. Because, there are other things to talk about in Massachusetts. It seems only in Massachusetts. We still haven't even gotten to Idaho yet. There's so many crazy things happening in Coburger right now. Good citizen, thanks for the 20. The same Norfolk DA is allowed to be on multiple cases that are involving the MSP screw up of the Norfolk County District Attorney's Office in Proctor. How can she not allow Bederow? That is a great argument. And it's like she's deciding what the ethical rules are. Like, I think she's wrong on the law, and because she didn't cite any law in her opinion, that makes me think that I'm right. I could be wrong. Wouldn't that be the same? Jump into my brain. I'm not good with words. I know what you're trying to say. Wicked psyched. Why would the Commonwealth be concerned about any discovery coming out, even if from another case? Isn't it their job literally to seek the truth? Yeah, it's supposed to be, but they just want the conviction. You know, if they wanted the truth, they wouldn't fight ARCA coming in, right? If they wanted the truth, they'd be like, bring in all the experts you want, because we'll just get experts to counter them. And when we can't, we'll get experts who have no business testifying in a court of law about the cause of dog bite injuries to John O'Keefe's right arm. But then the judge is just going to let him in anyway. So the deck is stacked. The jig is up. The news is out. They finally found. I mean, it's like Renegade. No, they're not concerned with the truth. They want the conviction. They want the win. They want the W. It's way, way bigger than the Karen Read case. Way bigger. From the light by Disturbed. When all is forsaken, listen to me now. Sometimes darkness can show you the light, and don't let hope become a memory. Hang in there. That's amazing. I like that a lot. Somebody else sent me a version of Disturbed playing Land of Confusion, and I am not familiar with Disturbed, but I really liked it. So thanks, Debbie. Brendan's fake apology, Noel, says there's only one reason Mark wasn't allowed. Michael Marcy got into Bev and said, deny it, Bevy. Hanky boy can't handle this amount of competent lawyers. Thank you. Debbie also motioned to add the light to the Karen Read playlist. Thank you. I'll allow it. Cannone's put a gag order on all attorneys. Thank you, Eileen. Thank you, Eileen. We went over that earlier. So I guess that I am way behind in the chats or super chats or not. That may have been, came on at what, 4:30? And now it's 6:30, and your super chat here was at 5:51, so you might have missed it. But yeah, that was the order on sanctions and, verbal oral argument for a gag order, like that she called a re-up of an old motion. So thank you. Thank you so much, but you'll have to rewind if you want to hear the coverage on that one. KRH, would that be the lawyers that came in for Attorney Steele in the YSL case? This whole case is unhinged to scare everyone. I didn't follow that case at all. June became a member. Welcome. T12, welcome. This case is like a box of chocolates. It is Coleen Alessi, David Reese. Grave digger. Bev is digging like a professional one, and that's a great Dave Matthews song. Love it. Psycho Mom is the gag order for the old case or the new case? I think it's for all the cases. It's until this case is over. But great point. Alessi's Google search, not. Every time Brennan says the Commonwealth are entitled to a fair trial, I scream there's only one side of the Sixth Amendment. You know it. I know it. Maybe Brennan doesn't know it. Rehomed Sallyport camera. They had all this lined up. They didn't think it would fail. That's why old paperwork was submitted. They probably had more lined up on that indictment. You might not be wrong. Hurl 69 617. This is ducking crazy. You can't make this up. I'm embarrassed to live in Massachusetts. Thanks for your super chat. As a criminology grad student, Carrie Ann is wicked horrified. Thank you. Bill T. Can Bederow still be involved behind the scenes? The order doesn't say that. Ethically, could he probably should not do that? It's not for me to opine. I am not a special, my specialty is not ethics and attorneys, but I imagine that he would know the answer to that better than I, and I will not opine on that. But thank you, Bill T. Karaoke, thanks for gifting a membership. You're so sweet. Tina, I'm curious what the conversation was Bev had with the jury when she said she'd be in shortly to see them. There have been jurors that spoke out, and I don't think she said much of anything other than, thanks for coming. Have a nice day. Officer Fanning will see you to the bus. Well, but maybe not. Maybe he didn't see them to the bus. But I think that the jury, did Ronnie ever mention what she said? Maybe Chatters, maybe you can help Tina. I don't recall. Team Wicked Smart. This case is giving syphilis brain rot. Thank you. Lady Macbeth became a new member and changed her name to fit the Shakespearean tragedy. And I have dubbed the judge Lady Macbeth. Thank you. Casey and the Sunshine Band. Thank you, Mama She, for telling me who that is, and I'll go listen to it later. Did my last super chat get lost in the ether? I don't know, because I'm way behind. I apologize if it did. I apologize, but it's just me. I don't have a team. I'm sorry. You're very generous. I know you're all the way in Norway. It's probably late for you. Perfect Quincy pronunciation. Thank you, Devin. Thank you. There has to be more going on with this judge that we don't know yet. The bias is blatantly evident. It's becoming clear to even Peter Tragos, and that's saying a lot because he really tries to be fair and, impartial. He tries to be impartial. I clearly don't try to be impartial. This is an opinionated channel. I'm never going to I can't sit on a fence because it's going to give me splinters. That's not what I do. And I feel passionately about something, but my bias is not biased. It is based on my educated opinion of the case from doing all of my due diligence and research and reading the papers and watching the testimony and things such as that. Thank you, Tristan, for becoming a member. T12, supporting justice for KP, for Karen Reed, Officer John O'Keefe, the niece and nephew from Florida. I lived in Chicopee, Mass. back in 2001 for 2 years. Your reactions make me laugh. Thank you. I don't drink, but I had a drink this afternoon, says Happy Annie. Thanks for tuning in from Canada. Work guy too. Karen has a great attitude and perspective. She is not scared. Therefore, she should prepare to take the stand, although not let the Commonwealth know until the last minute. Yeah, well, it usually is a game time decision. So yeah, I'll agree with you on that. I also will say that when we watched part 3 of the Ted Daniel interview, where it was just Ted and Karen in a car, and she did an interview, and we watched it, I think, before a hearing one day together, it showed a whole different side of Karen that most people haven't seen. And I thought so many of you thought that she humanized herself, that she seemed very genuine and honest, and she may be able to hold her own on the stand, and she probably does want to tell her story. But again, it will be a game time decision, just like it was last time. And the truth doesn't change, right? And the jury might want to hear from her. But that said, it's not easy to get up on the stand, especially when you're innocent. And so, yeah, I'm sure that she's not scared, but you can't help but be defeated on days like this, right? It's defeating to us, and we're not personally involved in this case at all. So I can't even imagine what it's like to be Karen Reed today. Casey Cat, you need to add doggy poo bags renamed Karen Reed trial bar bags to the merch shop. Hashtag bestsellers. I don't think they have that. Athente says, as goes the investigating officer, goes the investigation. Maybe. They're going to full steam ahead, this thing. Come hell or high water for April 1. And that's what they're doing. Piney Woods, thanks for the 10. I'm with you in spirit about this travesty. Please go have fun on your vacation. I got my fabulous shirts yesterday. Oh, good. Mine didn't come yet. Mine didn't come yet. And I ordered them before all of you did. And I called last night. I'm like, hello, my viewers are getting merch before me, and I needed to make sure it was good. So they're going to send me another package. I'm like, the package has been stuck in New Jersey for 4 days. What are we doing here? I'm glad that you like them. We have merch. I went to Cancun with attorney Melanie Little. It's a popular one. And then there's a free Karen Reed on the front. And there's a stay cool, stay kind, stay classy on the back. We are outraged. The merch link is somewhere below in the show notes, I think. I'll put it in the chat if you want me to. We must continue to show up for truth and justice. Yes, we must. We must. Remember that old thing? We must increase our bust. We must increase our bust. Increase our bust. The bigger, the better, the tighter the sweater. We must. I'm losing it. I'm losing it. I'm putting the merch link in the chat right now, and I'm going to pin it to the top, and you can check out all the new things, and they're fun. And sometimes we got to laugh. So I'm going to pin it. There you go. Thanks for asking. Bev might as well be called prosecutor at this point, or prosector. Her bias for the prosecution is insane. Thanks, Angela. Dennis says, Bev is a jellyfish, thus no brain. I'm more of a lessee. That gags me, but in a different way. Sheila, I have no clue. Okay, I'm letting it out. My nickname for Hankey's Pee Wee Herman. A lot of people have said that, Sheila. You're not alone. Thanks for your super chat. Piney Woods, please don't go away. Hey, do you hear it now? No. No. I got a worm in my brain, but that ain't it today. Combat 1, will gag order release after jury seated since they can't watch the coverage? No. No way. No way. It is especially important that they do not speak during the trial. It will have, they will be allowed to talk after an acquittal when there's finality. Dr. Russell is the GOAT. You got to it. Don't worry. Thanks, sweetie. I know it's 12:30 in the morning for you. I'm sorry. I should have looked through and picked your chats out first because you are so in a different time zone, as is Tristan. Thank you for your super chat. Amora Valesi says, Officer Fanning will be following the bus. Following the bus and then following the jury to the bars, maybe? You can't make it up. You just can't make it up. So there's that. Became a member. Welcome. So there's that. Thank you. Lisa Marie, so obsessed with your trial commentary. Thank you. So many people hate me so much that it's not even funny. I've been up till 3 watching you all week, just when I thought I couldn't hate Bev and company enough. Oh, thank you. Thank you. Free Karen Reed, Lisa Marie. Lisa Marie. Lisa Marie. You know who's great? Because I digress. First of all, Daisy Jones and the Six is one of my favorite series of all time, outside of like Jury Duty, which you guys have watched. If you haven't watched Daisy Jones and the Six, Riley Keough plays the lead. She is Elvis's granddaughter, and she is the daughter of Lisa Marie Presley. That's what reminded me of it. Say Lisa Marie. Riley Keough is her name. She's amazing. She didn't even know how to sing. She learned how to sing for Daisy Jones and the Six. If you guys haven't watched it, it is all things 70s. It's like, it's amazing. The fashion, the sets, the acting, the singing. I just loved it. I loved every minute of it. I think I might watch it again tonight to get me in a better mood. Tristan says he finally became a member in the middle of the night. In the middle of the night, like I'm walking in my sleep through the valley of dream. I don't even know if I got the words right, but that's a Billy Joel song. And, I'm a Long Island girl, so there's that. Happy Warrior says, I no longer view the justice system. I feel it is a judicial system that seems to be abused and selectively applied by persons who are clearly not siding by the oath they took to uphold and practice fair and unbiased rulings. Thank you for that. Thank you. Oh my God. Thank you so much. If you have $50 and look who's here. Look who's here. Thank you, Happy Warrior. I love you and appreciate you with all my heart. Larry's here. The TUI guy on Buckle Up says VNX lobster dinner. When you come to New York, we'll have a lobster dinner. I miss lobster. It's not really in season right now, but I do love lobster. And thank you for your $100. That is really amazing. And if you guys are not subscribed to the DUI guy, the only guy whose head might pop off more times a day than mine is probably the DUI guy, Larry, aka Larry. Took a little hiatus for a bit, but he's back and he's better than ever. And good on you for getting a little vacay and a little time off, because this can really suck the life out of you. I thought litigation was bad. Like I thought, I'm going to retire from practicing, try and do some other things for a while, because litigation really sucked the soul out of me, because I sued the Catholic Church on behalf of like all of the plaintiffs on Long Island who were molested by priests as children that were now adults when the scandal broke in 2002. It was a 16-year fight, sucked the life out of me. New York at the time was the most pedo-friendly state in the country, because if you could keep a kid long quiet enough, you would never go to jail. You could never be prosecuted. All the cases were thrown out on statute of limitations. The law was finally changed to allow for the old cases to come in. Whatever, sucked the life out of me. I'm like, I can't live a Zen life. So I decided to, try some other things. And well, here I am on YouTube. Who'd have thunk it? Who'd have thunk it? Not me. Kind of a happy accident. I love being here with you guys, but this is like, I don't cover cases unless I'm passionate about them. And it happens to be the cases I'm most passionate about are the cases where people are being wrongfully persecuted. Brian Camp, Penny McGee, Daniel Penny. We saw the 3 of them acquitted together. This will be the 4th. And boy, I can't wait for that day to come. Jerry says Bev is going to hate the movie. Yeah. Jules is here. Thank you. And says from down under, says, hey, yeah, in the Twilight Zone. Well, Twilight Zone upside down. It's the Hunger Games now. It's the Hunger Games. Karen Reed is Katniss. Because that's where we are. We're in the Hunger Games. I've never seen anything like this. Michelle, thank you so much. Says, buy yourself a glass of wine on the Venmo. Thank you. I appreciate you so. Donna bought me 3 matcha lattes and says, I can't love you more than I do. I do today for breaking all this down for us. You're the voice for all of us. Thank you, Donna. You're amazing. We went over the gag order. Yes, we did. The Goodmans are here. And Mr. Goodman says, ignore the naysayers in your chat. Mrs. G says you need a top shelf cocktail. $20. Give me a nice martini. Thank you. Thank you. I like the blue cheese olives, but too many of them are too salty. So I appreciate you so much. And Tracy Walker bought 5 matcha lattes and says, for your classy patience. Thank you for letting me be a kindergarten audience. I waited for your coverage. Thank you, Tracy. It's like sometimes I feel like the police, the good kind, or, the kindergarten teacher, but, sometimes people need a spanking. Or to go in the corner with a dunce cap on. The defense has 12 experts because most won't be allowed. Yes, Jerry, yes. But, Spanky's going to need a bit more time. Oh, you know what? It's time for Spanky's name tag. Here it is. Hello, my name is Hank Breenan. Most won't be allowed. And the Commonwealth has experts that fly in from many places because they can't find anybody close by within the jurisdiction or within the specialty that they need them to be an expert in to testify as to what they should be qualified to testify about. But she's going to allow it. So yeah, maybe that's me. I'll be the kindergarten cop. I like that, Debbie. I like it. I like it. T12 gifted 5 memberships. You're awesome. Thank you so much. And Michelle says, if it's bigger than Karen, how do they win? This corruption is out there for everyone to see. Why doesn't someone ranked higher do something? You guys are doing something. You guys are watching. You're listening. You're screaming. You're showing up. You're out there with signs. You're spreading the word. You're spreading the word to the world. And we ain't got no quit, right, Michelle? We ain't got no quit. So we're just going to keep screaming until something happens, until they just can't not pay attention anymore. Because if Fanning and Colleen Crawford have been working together since at least 2015 to alter videos, according to the case of Bourdreau versus Paul Fahey, this has been going on a long time. And those are just allegations, by the way. Those are just allegations because I haven't done my full-on deep dive into that case yet. But Hold My Halo says, I'm a new member. Thank you, welcome. But I've been watching and supporting for a long time. Appreciate you all. Listen, let me tell you something. Somebody said to me once, they said, every housewife in Canton knows who you are, but nobody will ever go in your chat and talk about it. I'm not even saying like housewives as like a derogatory term. Like there are people who, women of Canton, it's not Canton, it's Canton. They don't want to talk about it. They don't want to speak out. They don't want anybody to know who they are. I can't tell you how many anonymous people are anonymous. They want to be anonymous. They don't want to talk about it. They got to live there. It's going to be hard to find a jury in Canton, especially if they're going to get the stare down again. The stare down from Brian Albert and Colin Albert, or Coleen Albert, as they're calling him now, Coleen. Long time, first time, right? Remember the old radio shows when people would call in, they'd say, long time listener, first time caller. Jerry Gray says, I think we're going to see Auntie Bev's name on the cards at the courthouse. No, right. They're holding up cards outside the courthouse. Oh, Jerry was here. Jerry's in Canada, and he was here for the Aidan Carney hearings that we did. I think it was yesterday. Coleen is so fitting. Take care, Larry. Thank you. Thanks, Larry. They're talking about only to people that they trust and totally off the record. Yeah, and I get it. I get it. Thank Larry for his $100. That was really nice of him to come in. I'm gonna have to go into his chat. All right. You want to invade somebody, guys? Who do you want to invade? I'm out of words. There are no words. Mark Bederow is not going to be allowed in. I feel that she's wrong on the law. I feel that she's wrong on the rules of professional conduct. I feel that it's up to the client to be able to waive the clients to be able to waive the conflicts, which they clearly both did. If she needs to hear from Mark Bederow to reconsider her decision, I think she might want to do that. We learned that the motion for sanctions was denied, even though the defense admitted that they put some things that were in the protective order in their motions and they shouldn't have. David Yannetti got up and he admitted it and he said, I'm sorry. Liza Little got up and said, I drafted the papers. Oh, no, that's on the ARCA motion. Forget that. Dave Giannetti said, I'm sorry. I should not have included Proctor's text message, but everybody knows that Proctor hates the attorneys in this case because during the first trial, it was brought out that he hates me, Your Honor, because that was in his text messages. So it's not prejudice because there's no surprise. Everyone knows that Proctor hates the attorneys. She denied the sanctions motions, but she granted the gag order. And that's what we learned today. We learned the deck is stacked, the judge is biased. This has been going on for decades. And maybe, just maybe, Fanning and Crawford are in this far deeper than we know right now. Olivia, I hope you will run with that. And Coleen did it. A pooper Proctor production. I love the alliteration. Says, thank you from Canada. We're so interested in this here. Free Karen, hashtag free Karen Read Canada. I love it. I love it. T12 said, little did Karen Read know the day she chose to stand up and fight, she would unite people from all around the world. So that just makes me want to cry. That just makes me want to cry, number one. And number two, you guys are amazing. You guys are the reason. Runkle in 30 minutes. I'll allow it. If he allows the redirect. Some people don't. I'll look. You guys are the eyes of the world. You guys are out there. You're bringing it every day. And I couldn't do this without you, because without you, I'd be here, screaming into a closet by myself, very lonely. And that wouldn't be like fun at all. So we get to do it together. It's like, it's almost like group therapy, right? It's kind of like group therapy. Right? Okay, so hold on. Okay, I see that he's going live with Lawn Lumber. Is that it? The Friday Night Frenzy? Is that where you want to go? Hold on. 1 second. One second, because I don't believe it. I'm gonna have to check for myself. No. Mark Bederow is not live with Young Jerks right now. He titled his stream something about Bederow and put Bederow on the thumbnail, and it looked like it was a screenshot from an old show. And so I think that's what got you confused. But no, he's not live with them with Young Jerks right now. I think Young Jerks was talking about it. Where did I leave off here? Hang on. Kelly became a new member. Thanks, Kelly. Melanie, you can't tell me to drink and then make me laugh so hard I spit my drink out on the Coleen comment. Love you. Love you, Bella Brat, for you as well. Janelle says, Bederow's Young Jerks. No, it's over. And he changed his title too, because now it says something like Bederow denied. So there's that. I don't think Bederow is going to show his face on any kind of YouTube anytime soon. But Janelle, I do love you for your super chat. And Jerry says, don't ever change. I think you'll be a drinker after the trial. Time for a mega pint. It's not that I just, you know what? It's like, I drink. It's not that I'm against drinking or that I'm in recovery. Not that there's anything wrong with that. It's just that I feel like the older I get, the more it just doesn't agree with me. Like I get very congested when I drink wine or beer to the point where I need a box of tissues every night before I go to sleep. And just, I don't like feeling like garbage in the morning. And I don't like, so it's not that I don't. I might tonight, Friday night. All right. So here's where you're going. You're going on a cupcake invasion to Friday Night Frenzy. And here's why. Because I don't think Rob from Lawn Lumber knows who I am. Because he one day said when they were watching a Karen Read hearing to Runkle, the attorney Little, is that Melanie Little sitting at the defense table? And we know it's Eliza Little. But I don't think he knows who I am. So, you know what you're going to do? You're going over there. He's with Runkle. They do their Friday night thing. They're going to talk about Karen Read. And you're going to introduce yourselves and let him know who I am. We were both covering the Maya trial at the same time, too. So I don't know. Maybe he forgot. But he's been off YouTube for a while. So I am going to send you there. And the hubby and I in Massachusetts having date night watching me. We love you and are so grateful you're helping us bring the corruption to light here. So you and the Goodmans should get together because that's what you guys do on date night. You watch me, which I love. Hang on a second. I just got something here, but I just don't know what it is. That's to do with Sandra Birchmore. But I can't really segue into this right now, although I do appreciate the info. You're going to see me like all weekend, right? So don't worry. We'll get it all done. Anyway, holistic therapist, you and the Goodmans should get together on date night because all of you. Oh, Bob, you haven't heard that she denied Bederow's pro hoc vice? Yeah, she denied it. And then she ruled on the sanctions motion and she said no sanctions, but also gag order. But remember that motion to exclude ARCA is still hanging out there. And that's the one that she wants to pull the pro hoc vice status for Alan Jackson on. So we're still waiting on the edge of our seats. If you need the papers, call me or have Allie call me. I'll shoot them over to you. Love you guys. All right, you guys, I'm gonna shoot you over to Lawn Lumber. So to the Friday Night Frenzy stream. You're gonna do a cupcake invasion. As soon as I hit end on this, it will redirect you to hit your notification for that. I don't know what time it is because I'm too tired to look. So MSP can have a second job that conflicts with duties. Thank you, Colette Cahill, for letting me know that. I appreciate you. Thank you to the moderators who keep it like amazingly cool, kind, and classy in here all the time. They work overtime, double overtime, triple overtime. This is our second stream today. So it's insane. I love you with all of my heart. If I don't see you soon, I'm going to die. Just Google Clemens's meatball. Clemens's meatball scene. And you'll understand where that comes from The Godfather on YouTube. You can watch it. I can't play it. They'll strike me. Replay viewers, I love you with all of my heart. And just do all the YouTube things. Hit the like button, hit the things, share it out, respectfully comment. A lot of nickels. Thank you for your super sticker. And do a cupcake invasion over there on Friday Night Frenzy. Say hi to Runkle for me and introduce yourself. Introduce me to Rob. Safe travels, my friends. I love you with all my heart. Stay cool, stay kind, stay classy, stay calm. I know you can do it. I know you can. Free Karen Reed. Peace out, my friends. I'll see you soon. You thought I was going to flip the desk? I didn't. I held it together for the most part. I might have to cut that part out. Good night, friends. Make sure you got notifications set because you don't know what's going to pop off next, aside from my head. Good night. Safe travel.